Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas, and today we're going to discuss a more serious matter, which is employment discrimination, and specifically employment discrimination regarding a person's immigration status. There are two main situations that I see every day here at my office. One is if a person's applying to receive their green card, they have what is called an EAD card, which is an employment authorization document that allows them temporary work authorization while they're waiting for their green card to be processed. So if you have a temporary work card and you are working for a company and it's about to expire, so you file a renewal application, if you are under certain categories, your work card will automatically extend for an additional 6 months after it expires. So the categories that are eligible for this automatic 6-month extension are going to be listed on the screen. If your EAD card has one of these classifications listed, then you are eligible to automatically have your EAD card automatically extend upon the filing of a new EAD extension. So if your employers give you a tough time and they tell you that you're not eligible to work because your EAD card has expired, all you would have to do is point out to the regulations which indicate that there is an automatic 6-month extension for these classification types. The second main situation that I see occurs with green card holders. So whether or not you have a 2-year green card or a 10-year green card, the rules are the same. If you work for a new company and you have an expired green card, that employer can ask you for an unexpired green card or prove that you are maintaining your green card status. Now, if you are already working somewhere and when you started you gave them an unexpired green card, but eventually the green card has expired, if your employer asked you for re-verification or a new green card, this is illegal. They're not allowed to do this. So today I'm going to discuss a situation that happened approximately 2 weeks ago to one of my clients. In this situation, the client told me that she was very afraid because her green card was about to expire. She had a conditional green card, which is only valid for 2 years. And she's worried that the employer is going to ask her for re-verification documents like a new green card or prove that she was still eligible to work. I explained to my client that this is illegal, and if the employer did do this or tried to lay her off or terminate her employment, just to have them give me a call and I'll be more than happy to explain it to them what the law is and why they are unable to re-verify her employment status. So today I'm going to discuss what I did to ensure that her position was reinstated, she was able to go back to work, and also have the employer agree to give her back wages for unlawfully laying her off. The first thing that I did was I instructed our client to reach out to her HR manager or director and point out that the I-9 instructions specifically specify that employers are not allowed to re-verify the employment verification eligibility for green card holders, whether that be conditional or permanent green card holders. Now, when that did not work, what I did was I instructed our client to have the HR manager contact me directly. So usually after our office speaks with the employers, they understand that they have made a mistake and they usually allow the employee to go back to work. However, in this situation, they did give us more of a hard time, and I'm going to explain to you what you should do if an employer resists and they give you a hard time. The third step is to make sure that you keep all of the communications in writing. This means by email or through correspondence. A lot of times, employers will tell you that they want to see you in person, they want to discuss this matter verbally on the phone. I recommend that you write them an email and you just simply state, I prefer if we can keep our communications via email. This way, nothing gets lost in translation. And this is very important because you want to keep a paper trail of everything that the employer is telling you. So after you start documenting everything, the fourth step is just holding your ground. Because what will happen is that your employer may hire a third-party attorney, and that attorney only has the employer's interest in mind. This means that they're not going to care what happens to you, and they're going to start treating you as if you know nothing or if you're wrong about the law. Now, after holding your ground to make sure that the employer knows that you're not going to budge, the fifth step is to inform the employer or the third-party attorney of what you're about to do if they do not resolve the issues and comply with the I-9 instructions. So I recommend that you write them an email or a letter, and you're going to explain that if this matter is not resolved, you're going to contact these organizations that I'm going to display here. The organizations include the United States Department of Justice, the U.S. Equal Employment Opportunity Commission, the U.S. Department of Labor's Hour and Wage Division, the National Labor Relations Board, and if you live in Texas, the Texas Workforce Commission. If you mention all of these organizations, that employer or the third-party attorney knows that you mean business and that you're serious about taking this to the next level. So I understand that many of you watching are afraid to do this or will be afraid to do this. However, think about it for a second. The employer is doing something that is illegal, and you have a right to remain employed. If you do not stand up for your rights, you're going to be either laid off or terminated. And at that point, who is looking out for who? So you need to look out for yourself and make sure that the employer knows exactly what you are willing to do if the situation is not resolved. Now, after I said this, and remember, I mentioned earlier that the third-party attorney will pretend to be nice and then get overly aggressive with you. And this is why it's very important to hold your ground. But that third-party attorney came back and was just very rude in her email. I'll go ahead and attach the email to this video. That way you can see what you should expect when you're dealing with a third-party attorney that does not care about your rights or your feelings. So after she did this, I went ahead and just told her, look, I'm not playing around. You have 5 days to comply and give her back wages, or else I'm going to encourage my client to reach out to those organizations. And guess what happened? At the end, the employer agreed to pay back wages and gave the position back to my client. So if you follow these steps and you do exactly what we're telling you to do, and you let the employers know that you're not backing down and you know what your rights are as an immigrant, they're going to back down and they're going to do what they need to do. So again, thank you for watching Winning Law. I'm attorney David Nguyen, and hope that we have made immigration easier to understand.
At David Nguyen's Law Office, we are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.